Good morning, members of Personal Injury Compensation Committee. On behalf of Law Student Association, I welcome the opportunity to present this submission on a matter of pressing importance, general medical liability, with particular focus on failure to warn. My name is Shweta Sharma. I'm a Juris Doctor student. The submission evaluates the current legal framework concerning the duty of medical practitioners to warn patients of material risk prior to treatment, and it proposes targeted legislative reforms. Our goal is to ensure standard legal standards properly reflect ethical imperatives, respect for patient autonomy, and expectations of informed consent in today's medical practice. The submission will look at whether the current law and policy go far enough to protect patients. As mentioned, we will offer some targeted reforms that would make the law clear, fair, and more ethical for everyone involved. This issue affects three main groups: patients who need clear and complete information from medical practitioners uh, to make informed decision on their treatment or medical procedures. Medical professionals will have the legal and ethical duty to explain risk. Regulatory bodies who make sure professionals follow standards. Getting this balance right is crucial for both legal protection and patient safety. Let's go over a quick timeline to understand how law around failure to warn has changed over time. Before 1950s, medicine was parentalistic. Doctors made decisions and patients weren't always given full information. This wasn't much there wasn't much legal focus on patient rights, and failure to warn simply wasn't seen as negligence. In 1957, the UK case of Bolam and a friend introduced the idea that doctors were negligent if they followed the accepted medical practice. Uh, this became known as the Bolam test. It was used in Australia, including in Queensland, until the 1990s. Then in 1992, we had a major shift from with Roger and Whitaker. The High Court said that doctors must warn patients of material risk, not just what other doctors would do, but what a reasonable patient would want to know. This gave rise to a stronger informed consent principle and made patient autonomy a priority. In Queensland, the Civil Liability Act of 2003 um, outlines the law of negligence. It requires patients to show that there was a breach of duty and the breach of duty caused that harm. For people who can't make their own medical decisions, the Guardianship and the Administration Act 2000 steps in. But again, it is not always clear how well patients' rights are protected. Even today, some doctors still take parentalistic approach, especially with older patients who are used to that approach, um, and also patients with low um, health literacy. This creates a policy gap where many people don't understand their rights and never report something that goes wrong. This example of my elderly neighbor who went through a medical study and did have consequences after the medical study. She was not warned of the risk that she currently has. After a discussion, she said the doctor's right, they knew what they did, and I respect them. That's the approach our elderly have, and that's what uh, goes underreported, and that causes very less um, case law to reflect back to for negligence in healthcare and failure to warn. There are some serious gaps in our current system. The Civil Liability Act does not clearly define what material risk is. It does not require doctors to check or use a patient's full medical history before giving treatment. There is no obligation to use shared medical records. Most of the time, consent is verbal, which leads to he said, she said situation when something goes wrong. The My Health Record system is optional, and many people, especially the elderly or those in low income groups, don't use it or know how to use it. All of this means that patients are at a risk of not knowing the full story and their medical history, and the doctors can avoid legal responsibility too easily. These gaps cause real consequences. Patients have physical, emotional, economical um, injury by these treatments, and they don't fully understand. Older people often feel too afraid or unsure to question their doctors. Many cases, as mentioned, go unreported. And when legal claims are made, they are often fail because the law isn't clear and there is not enough documentation on consent of what was said and what was consented to. This situation often favors medical profession and protects them from liability, while patients are still left with no voice. So, what can we do to fix this? Let's start with changes with Civil Liability Act 2003. We recommend combine Section 21 and 22 of the Civil Liability Act. This way, professional standards and informed consent are treated as equal importance. Definition of material risk, to be clear, the law should say that the doctor must warn of all risks they know after they have referred to medical history, not just what they personally think is reasonable for a patient to know. And making written consent mandatory. Verbal consent is not enough in today's complex medical and legal system. Add a duty to check documents and document patients' medical history before treatment. This ensures the consent is tailored to a patient's needs. Introduce a shared medical system accessible by all hospitals and healthcare providers, public or private, across Australia. This would allow practitioners to give accurate warning based on patient's full medical history, including medical procedures done, medications, allergies from birth to death. We also recommend changing other key laws that go hand in hand with the Civil Liability Act. The Hospital and Health Boards Act 2011 in Queensland, the Information Privacy Act 2009 Queensland, and the Commonwealth Act of Privacy 1988. Our suggestion is simple: create a centralized medical record system that updates in real time from birth to death, like mentioned, including diagnosis, tests, treatments, medication, and allergies. This would reduce risk and improve care and support better the legal practitioners as well and the healthcare professionals. Uh, Reforming My Health Record. Next, we suggest changing My Health Record system, which is currently optional. We propose amending the healthcare legislation, the eHealth Act 2015, to make participation mandatory for all patients and healthcare providers to protect their rights. This would help doctors give more informed warnings, give patients better access to their health data, and link the systems directly to Civil Liability Act for legal references. Lastly, we would suggest changing the Queensland Health Guide to informed decision making. in healthcare, version 2.6. Right now, verbal consent is accepted, but that leaves patients unprotected in legal claims. We recommend that written consent be made standard, especially where material risks are involved. This creates a clear record of what is explained and what the patient agreed to, protecting both sides. To sum up our legal reforms, we aim to suggest define material risk in law, merge Section 21 and 22 of the Civil Liability Act, require written and consent and not verbal consent, ensure doctors access and document medical history, mandate a shared national record system, make healthcare mandatory. These reforms help prevent harm and make the system fairer for everyone. The law is not kept up with ethical expectations. Civil Liability Act does not protect patients in failure to warn cases, and it often gives doctors too much legal cover. To conclude, we believe these changes will respect patient rights, improve legal clarity, reduce unnecessary legal battles, and help restore trust in medical system. It will also help our social security, disability, and the NDIS, and help patients mentally, physically, and economically. Thank you.